Good afternoon and welcome. I'm Jennifer Caglio with CCBJ. We're thrilled to be working with our partner H5 to present today's webcast, AI and Privilege Review today and tomorrow. Our distinguished speakers are Doug Austin, editor of eDiscovery Today, Gareth Evans, partner at Redgrave, Bobby Malhotra, eDiscovery counsel, Munger, Tolles & Olson, Joy Morale, founder and CEO of Practice Aligned Resources, and Jeff Grobart, Associate Director of Professional Services for H5. We encourage you to ask questions as well as fill out the survey with your feedback at the end. If you're interested in the presentation or materials, you may download all of this using the icons located at the bottom of your screen. Today's webcast is freely eligible. Please be sure to answer all pop-up check-ins and enter your state and bar number in the survey. All states will be applied for after the webcast, and certificates will be distributed once the state approves. Sealy credit is only available for the live day and not on demand. And now I'll pass it off to Doug. Doug?
Thanks, Jen. Welcome, everybody. Glad to have you all here today for the session of AI and Privilege Review today and tomorrow. First, we'll start off with the agenda, which may be the easiest and most obvious agenda I've ever put together. Our panel of experts will spend some time discussing Priv Review today, including how most legal professionals currently handle it, the challenges associated with the way it's currently handled, and to what extent best practices and leveraging technology can improve the process today. Then our panel will discuss where Priv Review is heading and how artificial intelligence may impact that future, with their predictions as to what they expect to see in the next few years. Certainly, we encourage questions from the audience. We would love this to be an interactive presentation, so feel free to fire away with your questions, and we will try to get to as many of them as we can, either as we're covering topics or certainly try to save a time at the end for your questions there. As for introducing our panel, I'll go first. I'm Doug Austin, as Jen mentioned, editor of eDiscovery Today, which is a daily blog about eDiscovery, cybersecurity, and data privacy trends, best practices, and case law. I've been writing a daily blog for over 10 years, and I've been providing legal technology and eDiscovery consulting services for over 30 years. I'll let each of the panelists introduce themselves. So Gareth, would you like to go next?
Sure, thanks, Doug, and hi, everyone. I'm Gareth Evans. I've been practicing for 30 years now as a litigator. First 28 were at Gibson, Dunn & Crutcher, where I handled a lot of complex civil litigation and governmental investigations. A couple of years ago, I moved over to Redgrave LLP, which is a firm that focuses solely on eDiscovery related issues, including privilege. And right now I'm handling privilege matters in an MDL and a bunch of related state AG actions. So right now, privilege logging is my life, for better or for worse.
Very good. Thanks, Gareth. Bobby?
Sure. Thanks, Doug. Thanks, Gareth. And good morning or afternoon, depending on where you are. My name is Bobby Malhotra, and I'm eDiscovery counsel with Munger, Tolles & Olson in the Los Angeles office. I've been with the firm coming up on about 13 years now. Time flies. And my practice primarily focuses on advising our clients and firm attorneys on eDiscovery preparedness planning and execution issues, as well as information privacy and data security issues. I also serve as eDiscovery counsel to some of the large technology companies in the Silicon Valley area, where we regularly implement and test, privilege AI tools to see kind of which solution makes best for our various clients. So I kind of have that background as well.
Great, thanks, Bobby. Joy?
Hi, everyone. My name is Joy Morale. I'm in Los Angeles. I'm from Practice Aligned Resources. My background is pretty much over 17 years of managing and directing the global practice support groups and departments of Latham & Watkins and Paul Hastings. Now we focus on education and litigation support consulting for government agencies and corporations and law firms. Thank you, Doug, for having me.
Thank you, Joy. Jeff?
Hi, everyone. My name is Jeff Grobart, and I am a associate director with H5, my day-to-day life is primarily composed of working as an engagement manager, supervising review and search projects for a variety of law firm and corporate clients. But my background is also in data science, and so I also work with our product development team rather extensively, looking at ways to be able to bring existing and emerging technologies to make everybody's lives easier, whether it be internal or external users. And so looking forward to being able to talk about some of our vision for the future for how AI can address privilege.
Great, thanks, Jeff. Certainly, we've got a great panel here, and looking forward to jumping into this. Certainly, Jen already talked about accreditation, so I'll skip this slide, but here's how you can contact her if you have any questions. And of course, as always, any ideas expressed by us here today are our own, not those of our organization's clients or partners. So if we say something you don't like, blame us, not them. So when it comes to priv review today and how it's handled, let's be honest. If it were handled as efficiently and effectively as it needs to be, we wouldn't need to be here talking about it. So let's start with some background information to set the stage. And Bobby, I'll start with you. Can you briefly discuss for our audience how a priv review is typically conducted today?
Sure, Doug, and that's, I just want to note before I do that, it's somewhat of a loaded question, but I'll try my best. Privilege review, I think, is really a multi-step eDiscovery process. There's typically a stage at which responsive documents initially get coded for privilege during first pass review. Then documents that are deemed as privileged at first pass get sent to a second pass review for final determination of privilege status. Typically, this is a very manual process consisting of eyes-on linear review, guided somewhat by search terms, and priv screens that aren't usually very effective since they're both over-inclusive and under-inclusive. For example, searching for terms such as privilege or work product. As you can imagine, it's a slow, tedious, and expensive process as you're making final privilege determinations document by document, and then for documents deemed as privileged, you're actually deciding whether to redact or withhold and then implement redactions. And because privilege calls could be very nuanced and challenging, oftentimes during this manual process, human reviewers and priv screen search terms either fail to capture privileged documents or treat similar versions of privileged documents consistently. So in essence, Doug, I would say, at least in my view, the traditional privilege review process is kind of riddled with problems and challenges.
Certainly agree with you there, Bobby. Obviously, there are other approaches available. Gareth, why do you think most lawyers and legal professionals continue to perform priv review the way Bobby talked about and don't give consideration to other approaches that leverage technology more?
Well, I think as imperfect as the process is, it works somewhat. It works at least imperfectly. But it's a lot like document review and search terms and then attorneys' eyes on the hits. It's kind of the playbook that has generally been followed for many decades now. And I think that we're starting to see the emergence of technologies and their occasional use because the wheels start falling off of the bus as you're careening down the hill with these massive volumes of documents that we typically have to deal with in all kinds of litigation, but particularly in complex matters, and in your MDLs and your governmental investigations and your large class action lawsuits and antitrust lawsuits. The volumes are just incredible, and so being able to do it through that traditional method is really being strained. I think there are also, in terms of, there's a certain, I think, there's a lack of awareness of other methodologies, and that certainly plays into it. There's also, I think a fear of trying something new when you've got something that at least works fairly well, particularly given the stakes. So I think for lawyers, the stakes in privilege review and privilege logging are very high. First of all, there's an ethical duty that lawyers have to protect the privileged communications of their clients. Second, the most important and sensitive communications that a business or an individual will have are communications with his or her attorney, and privileged communications. There's almost this stigma attached, and probably rightfully so, if you inadvertently produce documents that you should have protected. And while you can claw back, in some instances, documents that were inadvertently produced, that can be very expensive and time-consuming, and you can't unring the bell. So I think those are all factors that play into why we continue to use the tried, if not entirely true, methodologies.
Yeah, certainly the stakes are high, no doubt about that, Gareth. So Joy, what do you think are the biggest drawbacks with the current approach to priv review?
Well, like Gareth mentioned, like when it works, it's great. So I think the drawbacks is when it doesn't work, right? When you do have documents that, first of all, are inconsistently coded or maybe not completely reviewed or redacted in the way they should be. So maybe the inconsistent handling of documents that we've identified as being privileged, first of all. I think with the large amount of data we have, there's almost like data blindness at some point, right? So if you're not leveraging email threading and inclusiveness, document reviewers or the review team can just kind of get blinded by some of the repetitive information and just say, oh yeah, I've seen that before, it's nothing, and move on. So I think that when it doesn't work, the biggest drawback is when you don't leverage technology, how are you approaching and handling the people part of everything, right? In the sense of it does wear them down. But the second part, when it doesn't work, Gareth, you mentioned the clawbacks and like the 502D, and sorry, it's getting dark out there now behind me. But when you have to go down this path of arguing what we have on the privilege log, going in forward to do like an in-camera review, all those unnecessary steps that we actually have to go through when maybe the process isn't working and we're not being as effective with showing them why or being as transparent to why these documents are privileged. And what I mean to that is maybe the categorical privilege logs that some teams have taken in regards to lumping things together or categorizing them. So maybe it opens you up to more risk in regards to people arguing and trying to move forward with those lines of strategy to handle that. But you mentioned also the fear of the technology. We talk about as a litigation support professional, it's our job to help provide options and be very clear on what the workflows are when we leverage new technology. And it just is changing so much, and there's so many options in some regard that it's hard for even the technologists to keep abreast to the new and the latest technology, and even instill confidence to the lawyers who are going to try to adopt this, right? So can we expect you to have an understanding of the technology and be able to explain this black box or the concept of this technology when we as technologists can't even explain or use it for you? So I think those are some of the drawbacks, is that the technology is changing so fast. Education is not there for people where we've worked out the workflow a bit more. And again, that fear of leveraging new tools and change management, it's natural, right? It's going to be there. So I think those are some of the drawbacks of leveraging technology and privilege logs.
Yeah, that certainly makes sense, Joy. So since you've alluded to Rule 502D and Gareth talked about inadvertent disclosures, while we're talking about the current approach as legal professionals, Gareth, let's talk about 502D and what sort of protections does it offer in the event of inadvertent disclosures of privileged info?
Yeah, so Federal Rule of Evidence 502 is something that everyone really should familiarize themselves with. It does provide some important protections, one of which is 502A, which provides that essentially there's no subject matter waiver by producing a privileged document. So there may be subject matter waiver for other reasons, but as a result of production of a privileged document on a subject, whether it's inadvertent or not, you get the waiver on that document, but that document alone. That can be very helpful because one of the issues that arises is people spending a lot of time trying to figure out whether a particular document really is privileged that goes far beyond what its importance to the case may be, but you need to do it because you don't want to waive subject matter as to the protection of privilege on a particular, subject matter or category of information, even though this one particular document isn't important. So that's not an issue in federal court anymore. Some states have followed, but not all. So that's one of the things that you do have to navigate. Rule 502B provides the fallback now in terms of standard. It's the idea was having a uniform national standard for waiver through inadvertent production. And I think the key factor in 502B is so long as you took reasonable steps and acted promptly to get the document back, there's no waiver with respect to that document that you inadvertently produced. Now, you oftentimes get into battles with the other side over how reasonable was your process, how reasonable were your steps. A lot of privileged documents being inadvertently produced will oftentimes lead to an inference that, oh, well, you didn't really employ reasonable steps. And then the real big important one that Joy and Doug have referred to is Rule 502D. And Rule 502D provides that the court can enter an order that essentially puts in place a no-fault right to claw back, whether you're and it does away sort of the disputes over whether you took reasonable steps or not. It simply provides in its purest form that if you inadvertently produce documents or even advertently produce the documents, you can claw them back. Now, what happens, I think, in practice is that the parties and the courts will oftentimes try to craft the 502D order in such a way that it doesn't lead to abuses or unfair sort of results for a party, like you're clawing back all the important documents the day before trial. But 502D is very, very important, and should, a 502D order really should be employed in every federal case.
Yeah, and it not only protects you in the case you're in, but in any other case as well, which is really key. I should note that the Sedona Conference Commentary on Protection of Privileged DSI is a great guide for anybody who's looking to effectively manage the protection of privileged DSI. And one of the principles discusses the importance of Rule 502D orders. It also includes 2 sample 502D orders, including one from now retired Judge Peck, who, if he's watching, would certainly be reaching out to me if we didn't talk about 502D. So you're welcome, Judge Peck. Another principle certainly discusses the importance to make use of protocols, processes, tools, and technologies to reduce the costs and burdens associated with privilege assertion. So let's talk about that now. And a great place to start is with something we all know well, which is keyword search. So Jeff, can the current approach to keyword searches for privileged documents be improved, and if so, how?
Well, if folks are going to continue to use keyword searches as the method for identifying potential privilege, I think the important thing there is to be mindful of what you're actually searching for. In my days of preparing and implementing privilege screens, it was surprising to see how often the ask from the attorney teams I was working with was almost always started with PrivStar, ConfiStar. And while those terms certainly will capture documents that are going to be privileged, they capture a lot more than just the true privilege documents in the population. On a recent case, when we looked at things after the fact, kind of assessing how well generic terms like that actually performed, less than 10% of the hits actually wound up being privileged, while it comprised something like 70% of the overall privilege universe that was being identified. So focus on privilege actors, privilege organizations. People that will break privilege are probably far more important than identifying what will capture privilege, because being able to eliminate documents from your privilege review is probably just as important as capturing the potential privilege as anything. So going beyond the step of just identifying opposing counsel, but what other third parties are present. And part of that, I think, is redefining the order of operations that most folks are using in everyday practice, which is put something like a names normalization process at the very beginning of the order so that you know what the organizations and who the individuals are that are in the data set that are at play, so that you're working from a position of knowledge instead of assumption about what's going to be present. Because otherwise, what inevitably winds up happening is some attorney name will pop up midway through a review that nobody was aware of, and then you have to go back and sweep in new documents that were missed, and then it raises the question of, well, who else did we miss? Why did we miss it? And how is this name not captured because of other reasons, other than some random generic term that, we were lucky to have included. So terms alone, I don't think are really the best method, but if you're going to use them, be smarter about how you apply them.
Yeah, that makes perfect sense. And to add to what Jeff is saying, I recently wrote about a study, a copy of which I believe is in the resources section, published on Law 360 by Robert Keeling and Rashid Chatwal, where they took 3 actual matters and benchmarked the results of different search terms for privilege. And the rate of success of retrieving privileged documents varied widely, from as high as 80 to 92% of search terms associated with outside counsel domain names resulting in privileged documents, all the way down to 5 to 8% for terms like legal, priv with a wildcard, legally, lawyer with a wildcard, and ATTY with a wildcard. So certainly some search terms are a lot more efficient and more cost-effective in supporting priv review than others. Did get a question. Somebody asked, are there any recent cases specifying what constitutes a reasonable step under 502B? And I know I've covered some in the past. I will have to look at that. And so if you, I will take that as a blog topic to research, and we'll be happy to post something like that on eDiscoverytoday.com here in the near future. So Gareth, what other approaches that are available today can be used to make privilege determination more efficient and more consistent?
Well, I think email stringing, deduping, and near deduping can be really effective. You basically, you don't want multiple reviewers to be reviewing the same documents again and again. So first of all, it costs a lot of money, right? Second, you inevitably end up with inconsistent determinations, and you want to avoid that, particularly with redactions. So what I'm seeing a lot more privilege logging for redactions and making redactions rather than withholding entire documents. It particularly comes up in email and other types of back and forth communications where there'll be a portion that may be privileged, but it's not the entire thing. And one of the biggest issues and problems that you see with kind of the traditional methodologies is inconsistencies in the overall privilege calls, but then also particularly in redactions. And by using stringing and deduplication, near duplication, you can go a long way to at least addressing that issue.
Yeah, absolutely. We have another question from the audience. What is the name normalization process? And Jeff, I was just about to ask you what other approaches have you seen in your cases that facilitate priv review? So maybe you can incorporate that as part of your answer.
Sure. I'll start with the names normalization. And all that really is taking an approach to, in any data set, there's going to be different versions of any person's name as it appears based on how their email address might appear. So whether it's an internal address that just has an exchange address where it's a long string of letters and numbers that is hard to discern, but at the end of the day, it shows first name and last name and the internal path for how their name appears versus, my email address, jgrobart@h5.com, depending on how you receive it, when you receive it, whether we've corresponded before, it may just come across as just my email address. It may come across with an alias that puts my first name first and my last name last name first name last. Depending on how you might have me in your address book, it might be Jeff, it might be Jeffrey. All of these things create dozens or more variations on any one person's name. And as Gareth might attest in terms of priv logging, you want to get that down to a single version of everybody's name that might appear in a given data set. And so the normalization process is a method to say, okay, every time this person's name appears, regardless of the format, I want it to appear exactly this way, Grobart, Jeff. And at the same time, if it's an attorney, do we want to have an Esquire after that or some other designation to be able to clearly define who is or isn't an attorney? And so by having a process go ahead.
Sorry to jump in. I think what Jeff is saying alludes to one of the things about privilege logging, which is I think there are a few things in legal practice as detail oriented as privilege logging, and how the names appear on the log are one of many of these kind of dotting the I's and crossing the T points with privilege logging.
Yeah,
right.
And the other thing, just a quick note, you don't necessarily have a requirement to clean up all of those names. I mean, it really goes to your negotiation strategy. We often, when we're negotiating the substantive and formatting requirements around a priv log, we often put in kind of metadata will be provided as is. But we don't have that obligation. There's obviously some internal benefit to having names normalized, so you're not looking at Bobby.Malhotra, B. Malhotra, Bobby M. It's all normalized to one name. So there's an internal benefit there, but I just don't want to get people alarmed into thinking this is something that's mandatory. It really depends on what you've negotiated with your adversary, the local rules in which you are litigating, and a myriad of other factors. So just to kind of clarify that point as well for the audience.
And
Bobby, those are really important points. And I think, there've been a couple of references now to categorical logs and then metadata only logs. And those are definitely both, approaches to help deal with the challenges of having such large volumes of documents and logging them. And in some jurisdictions, particularly in New York, the preference is for having a categorical log, at least initially, and then kind of taking a more iterative approach as there are questions about what's on the log and potential challenges.
And I was just going to jump on that with Bobby's comment of your strategy, right? That names normalization, if anything, could be used to, again, as I mentioned, battle your own review fatigue and making sure that you are being as consistent and comprehensive with your players as you can. So even if you don't hand it over to the other side, you could at least leverage it on your side to enhance or at least eliminate some of those drawbacks we mentioned earlier.
And that's why we're talking about the idea of kind of flipping the script, where traditionally names normalization has been something that's been very manual and typically saved for the end of the process, where some paralegals or some outside consultants might be poring over spreadsheets and doing all of this work in a very again, manual fashion, where there's tools available now to be able to automate that process, to be able to facilitate that beginning of the process improvement in identification of and organization of information, so that you know who the players are, how to organize them, and how best to be able to prioritize potential privilege as a result. So that's to the larger question that Doug started us with, which is how to better organize things. That's one way, and it also speaks to really kind of my number one recommendation, which is organizing your review based on what type of privilege hits or identification methods are being used. So to piggyback again on what Doug had mentioned in terms of the frequency of true privilege being present, whether it's organizing based on our attorneys in the metadata as far as senders and recipients of emails and the families that go along with those, are they being mentioned in the body of the document, or are they authors of a document itself, which may be indicative of some work product? Or is it a document that only references generic privilege terms where, in some organizations, there's this misguided belief that because the words privileged and confidential are added to the top of a document, it automatically makes it privileged. The realities of it are that if there's not a provenance for what makes it privileged and confidential, it's hard to support that claim. In other instances, I've organized a privilege review simply by who the correspondents are. So are the correspondents in an email exclusively internal correspondence? Is it exclusively internal with outside counsel plus known third parties that are not going to break privilege? And then finally, any third parties that may potentially break privilege, so that then you can effectively triage the review based on the likelihood of, in either scenario, triage the review based on the likelihood of privilege, so that then if there's a time constraint, if there's a concern of fatigue, if there's a concern about being able to start blogging and producing documents of greater or lesser concern, you can really organize your review around where the probabilities of privilege actually being present might be. And then if there's any concerns about the quality of the reviewers that are doing the review, you can also ensure that you're putting the best reviewers on the documents that you're most concerned about, and avoiding potential issues from a consistency standpoint in that way as well.
Yeah, those are all great points, Jeff. So Bobby, with some of the approaches Jeff just talked about to improve priv review, what's holding the legal community back from embracing some of those, and what can we do as an industry to improve adoption of these technologies and approaches?
Thanks, Doug. That's a great question. Another loaded question. I think that what I'm going to say is kind of going to touch on the theme of kind of the presentation today. I would say that the biggest challenge is trying to get folks, often lawyers, who tend to be creatures of habit, who aren't always, for lack of a better term, the most cutting edge, to believe and trust that AI works. And not only does it work, it delivers just as good, if not better, work product than traditional review workflows that they're used to seeing. And hand in hand with that, there's also a general lack of understanding regarding the available tools and technologies in the marketplace, because it is not 2015 anymore, or 2017, right? We're in 2021, and things have changed just in the last year or two. For example, not all tools and processes are created equal. Traditional TAR and AI tools typically have achieved, haven't been good at achieving the heightened level of recall required by a privileged review. So what I mean by that is, in a responsiveness review using TAR, an 80% recall rate may be acceptable. While in a privileged review, an 80% recall rate is almost never acceptable. If I went back to a general counsel of one of our clients and said, 20% of your privileged documents are going to be inadvertently disclosed, they would probably tell me, let's not use this AI. Right? So the margin for error here is much thinner. I mean, as Garrett pointed to earlier, you're dealing with kind of sensitive documents, and you want to be very careful. They're not providers that offer really both a service. What I mean by that is they offer experts who can tweak a classification model for the required data set and client. They're experts in privilege. They know the ins and outs of privilege issues. Oftentimes, sometimes they're linguists, sometimes they're other kind of tech experts. But the bottom line is they offer a team of consultants that can help you tweak a classification model. So they offer that service. And they offer a software, right? So now they offer a classification tool, but that classification tool is not the same classification tool as we think of in TAR technology. It is more focused on things that do well in privilege, such as people, right? Who's communicating with them, context, and relationships, as opposed to just that four-cornered content as we're used to seeing kind of in the TAR world. And those providers really tend to do a much better job in privilege identification projects, in my experience, and they tend to get in the upper 90th percentile in recall, which is where you want to be tracking if you're dealing with the sensitive area like privilege identification. And I think as an industry, we really need to do a better job of explaining which tools work for a given task, how these technologies really work. And I think Gareth mentioned this earlier, so hopefully we can eliminate that black box stigma and the notion that machines are running the show without any human involvement, because they're really not. I think it's a process and a technology, and people are helping to guide the workflow.
Hey, Doug, are you frozen? It looks like we're having some technical difficulties. Thanks, Bobby, for that answer. Does anyone else want to jump in and add to what Bobby just said?
Well, if it's okay, I'd like to jump in and address a question that has come up, I see, from Professor Richard Marcus from UC Hastings School of Law, which is, if the review is done right, is preparing a law a big additional task. And I think generating the law can be a pretty automated process these days, but the old adage of garbage in, garbage out also definitely applies. And if the review is done right, then that gets you, a lot of the way there. But that's a big if, and I include in if the review is done right means if the privilege call is right. And, I think what you typically see now in large litigation and investigations is you need to employ large teams of contract reviewers to do the first level review and on the logging issue to not. And I think the inclination of most reviewers, shall we say, is to be over-inclusive. Is if there's any possibility that something is privileged, they mark it as privilege, and then that gets it into your logging workflow and kind of working out then whether this really deserves to be on the log or not. Can be quite a bit of work. And then there's also, the issue of, okay, what is the description or the basis of privilege that is going to be put on the log? What is the narrative? And those can be almost like mini legal briefs at times, just kind of depending on the case, depending on sort of what your opposing party is demanding and also what the court is demanding. What I've seen is that oftentimes you get into multiple rounds where you may have a more high-level description initially, but as individual entries in the log are challenged, you then supplement with more detailed information. But it can really be a very time-consuming process. So yeah, generating a log, if you got everything set up right, you can kind of press a button and do it. But to get there, I think there's a lot that goes into it before you get to that point, at least on the sort of traditional methodology. We're going to talk about how you can use AI and how you can kind of leverage that to improve the process. But that's my answer to that particular question.
And just one quick footnote to that, Gareth, and I think Jeff is going to talk about this. These AI technologies are providing a very helpful output as it relates to the privilege laws, and providing description information. Is it a reflection of legal advice? What is it about? Obviously, it's generating and doing some of the names normalization we talked about earlier. So a lot of the output is being generated by these auto models, but it is really up to the lawyer to, one, negotiate with the other side, to negotiate a format where we can use that output and streamline kind of the privilege log process. And two, as you mentioned, Gareth, develop the QCs around the process, because garbage in, garbage out, you have to have a validation and QC approach, even if it's automated. I know Jeff is going to touch on that a little bit more in a few minutes.
Yes, thanks. And can y'all hear me? I hopefully am back. Good. I have a bone to pick with AT&T after this, but I seem to be good for the moment. So we'll pick things back up. I know we're getting a lot of good questions, and we certainly want to get to those. But we also want to get into some of the tomorrow stuff. So let's move into that, and we'll circle back with some of the today stuff as well as we go from that standpoint. Certainly, we're beginning to talk about supplementing and supplanting our current approach with AI. But one of the things we've talked about, I think, really a lot is the litigation use case. But Joy, are there other use cases for priv review that you're seeing and that you expect to see more of in the future?
Yeah, I mean, definitely so. And just going to litigation to that end, that there are counterparts like criminal, right? I mean, there's a litigation-esque component to that, but there is, in regards to search and seizure, having data that needs to be cleansed before it reaches investigators, for example. So there is a priv review. So maybe not a log per se, but the concept of needing to filter through large amounts of data pretty quickly, right? I would say criminal. Also, when you talk about non-litigation matters, and maybe it's pre-litigation in regards to like internal investigations or having to respond to third-party subpoenas that maybe you're not a party to the action, there is this need to turn over or transfer data. So who are you transferring this data to? So again, need to do privilege review, making sure you're separating any documents that you don't want to waive privilege on those things. So you just have to be very mindful that the concept and the actual work of doing a search for privilege information is outside of litigation. It's whenever you're requested to turn over documents, right? But also when we're in a law firm standpoint, you're just thinking of internal operations. When lawyers or clients leave one firm and go to another, it's not privileged per se in regards to the client's information, but we usually will do a review for our own internal law firm material that's maybe it's confidential material or commercially sensitive information if you're a company. So the same concept of having to filter large amounts of data and withhold in some information from putting it out, I think that kind of opens it up to compliance groups to just, again, records departments for law firms or other areas that you have to transmit data. So I think, and public records acts, right, like government side. There's a lot of exemptions that go beyond typical or standard litigation or civil privilege. So needing to, again, to be mindful of those, and then not, of course, like data privacy issues, right? The concept of filtering information and not releasing it is what I would think of.
Yep, those are some great examples. So Jeff, certainly we're seeing some applications of AI technology now. And there's a bullet point on here, application of deep learning models. So how do you see the next phase of AI with Priv Review evolving and working for the legal community?
Well, I think it's really going to address the item that both Bobby and Gareth had mentioned earlier, which was that the existing modeling of capabilities and approaches that folks are familiar with as it pertains to relevance reviews have been historically poor uses for identification of privilege, and it's because of the way that those models are designed and they work. They're generally designed to look at the content of the document and tokenize the language, and by tokenize it just means convert the words into numbers, and identify relationships between those words and what a person coded the example documents or training documents to reflect relevance or, in other instances, privilege to be. And in the vast majority of instances, limited to no metadata are being leveraged outside of what may actually appear on the face of the document. So with emails, you might get the sender and recipient information, but that's really it. And it means that you're stuck with that non-normalized, sometimes difficult to parse information that shows up in email headers. As a result, every time I attempted to model for privilege in the past, it's been a disaster. Now, currently and in the future, I see that as being something that's going to change rather dramatically as new and different modeling technologies become available. Right now, what has really piqued my curiosity and makes me want to dive deeper into it is the idea of reinforcement learning, which is the same technology that is behind what folks are using to create self-driving cars and teaching robots to walk, and really meant to mimic human behaviors, but it can also be used to mimic human thought processes in a way that is different than what folks might understand existing deep learning models and other, kind of current technology might be, and truly learn from an expert. And, the way that I think of it is, what partner or associate wouldn't want to train a coworker who never gets tired, never forgets, never takes a break, and will always follow the instructions that they've been provided and find relationships that may not otherwise exist to humanize by analyzing not just the text and not just the metadata, but evaluating all of it together to find the best path forward. Again, it may not be the best. It's very nascent, right? It's something that's worth studying and diving into and seeing where the threads take us. But it seems exceptionally promising and provides an opportunity to get to those thresholds that we talked about getting to a recall of 95, 96, 98% with an acceptable precision that goes along with it, because it really can start creating a brain. And in the context of, say, as a corporate asset, it's something that you can then leverage across a corporate entity instead of it being a one and done model like you almost always have to do in a responsiveness review, because responsiveness for case A is almost always going to be different than responsiveness for case B, whereas the rules for privilege are pretty consistent regardless of what case you're talking about. And so being able to build that computer brain to help identify that, it's not going to replace the human element to make the final decisions, but certainly a path to success. There's plenty of other things, but we're running a little short, so I'll give others an opportunity to jump in.
Yeah, Jeff, if I can jump in. So, when I think of AI in litigation, I think of what we refer to as TAR or predictive coding, or it's often referred to as supervised machine learning, so that the model, so to speak, is educated by the calls of reviewers as documents are presented to them. And I take it that what you are talking about in terms of like the AI of tomorrow is something that goes beyond what we currently have with kind of our supervised machine learning TAR algorithms for identifying relevant and responsive documents. Have I got that right?
That's right. It's a little bit, the idea is to have it be a lot more nimble than the existing TAR 1.0 or even the active learning models of today, where essentially there's a target and reward paradigm that's with the idea of the reinforcement learning. You set a target of properly identify privilege documents, the reward being the machine gets a reward of plus 100 points if it gets something right and minus 100 points if it gets something wrong. But it gets the reinforcement from attorneys as they review the documents, so that then, much like what you would see in a current active learning paradigm, you can float documents that are the most likely to be privileged to the front of the queue, and at the same time effectively cut out documents that are not going to be privileged. So it's kind of a hybrid of the supervised learning, like what you're talking about, but also leaving it to be unsupervised in as much as it's not round-based. It's not, create necessarily a set of documents to look at in a certain period of time, but rather as decisions are made, as documents are coded, the model will actually get that feedback almost in real time.
Okay. Yeah. So
that's the working theory, at least, right?
Okay. So,
it's all on paper right now.
I think it's important to say that TAR as machine learning classifiers, are being used today in connection with privilege reviews. Largely in situations where the volumes of documents are so large that the costs and also the time it takes for sort of eyes-on human review of every document just make it not practicable. But I think, as one of the questions points out, a lot of privilege calls can be very, very nuanced and difficult, and they're not always between, lawyer and client. You get situations where two non-lawyers are discussing the advice of a lawyer. And I think, those can be challenging. Now, I think, through supervised machine learning, the model can be trained to identify those sorts of things. But it's a challenge. And, as a lawyer, I would love to see this really work flawlessly. And I think what you're saying, Jeff, is in the future, we're looking at sort of more sophisticated machine learning, which will, lead to, theoretically, hopefully, excellent, good results in these more complex situations.
That's the idea.
Right. So we
I
have
think
about...
the way it is now, when you're using When you're using, a TAR type tool in, your privilege review work, there's, you want to be doing obviously, a lot of QC to make sure the model is adequately trained and also to make sure it's not missing privileged documents.
Absolutely. And we have about 5 minutes to go, so I'm going to try to I'm going to save my last question for the panel to the end and see if we can pick up on a couple of the Q&A questions real quick. So here's a question: how are review workflows changing with these newer tools? For example, are they replacing second-level priv review or removing privilege coding as a requirement from 1L review, et cetera? So panel, any thoughts on that question?
Well, this is Joy. I was going to just kind of refer back to what Bobby was mentioning about how privilege review tends to stream all the way from first, second, QC, all the way to the end. I don't see it replacing second. I see it being taken out of first. I see, doing what we can to triage, I think it was Jeff mentioned, triaging the population and bypassing first pass review and having, again, looking at resources who are better at making those privilege calls and only looking at those privileged documents once versus it having to go through 2 or 3 different lines of review before feeling good that it's been coded correctly.
Yeah, and I actually, that's a good point, Joe. I actually call that, in my view, the holy grail of privilege review. That is, as you mentioned, taking privilege determinations completely out of the hands of the L1 review team. There is no decision-making. Even if you're running a TAR review for responsiveness, there's no privilege component to L1. Instead using AI workflows and automated privilege determinations to replace that function. And the thought being, and in my experience as well, that the AI tool will help you curate a more core set of likely privileged documents, a smaller targeted set that is very rich in privilege that you can funnel up to the second level team to make the final calls or use some of the automated outputs that are being generated at the AI level. So I think that's how workflows are changing, and that's where I'm trying to head in practice more and more is really what I call that holy grail, just taking that privilege review component out of L1 review hands and relying on L2, but L2 making, quite honestly, better and more targeted privilege determinations than you see as that human reviewers when compared to the human reviewer counterpart.
Yeah, no, that's a great point, Bobby. So a couple of minutes left. I'm going to ask a final question for each of the panelists. If you can give a brief thought to it. Look to the future. What do you think the landscape for privilege review will look like in the next 2 to 3 years? Do you think most legal professionals will continue to do what they're used to doing, or do you see many more of them shifting to the use of new approaches? And what do you think it will take to get the community to move forward toward the use of newer technologies? Bobby, I'll let you start.
Sure. So I'll tackle the first question. I really do see an increased rate, I'm seeing it already, of adoption due to a various number of drivers, including one, an explosion of data volumes that we keep talking about. 2, there's new enhanced regulatory requirements, right, that are going to be impacting kind of what you do on the privilege review side as well. And then when you layer on top of that, the litigation risk and exposure that Gareth and others talked about earlier, that are associated with the traditional privilege review process, which we talked about is riddled with problems. With those 3 factors, you kind of have this perfect recipe of drivers pushing AI to the forefront. So I really do think we will get an increased rate of adoption in the future.
Great, thanks, Bobby. Joy, your thoughts on the future?
Yeah, I think the future, as corporations are becoming more sophisticated with their legal operations and their connectivity between legal and IT and compliance and all the other groups that really drive the management of their data governance or their information governance programs, being able to work together and get a larger ROI on documents that we've already classified as privileged in previous reviews. We always tend to give back our clients the productions, but no one's really asking me for the privileged data or what are the paths or the MD5 hashes of documents, excuse me, that we've already marked or as identified as privileged. So somehow going back upstream and marking those privileged somewhere that don't release them or don't review them again.
Yeah, no, that makes perfect sense, Joy. Gareth, your thoughts about the future?
Yeah, so I think that desperate times call for desperate measures, and maybe that's not the best analogy because I don't think that this technology should be seen as desperation, but I think that's kind of where it is right now, and I think there will be kind of slow increasing adoption in the next couple of years where you just have to do it because you don't have any choice. I do think that the point Robert Brown of Bloomberg Law has made in his question about how privileged calls can be very nuanced, particularly in-house where you have the two hats issue with in-house counsel, and how is AI going to recognize when the advice is non-legal versus legal between in-house counsel and other individuals in the organization. And I think that kind of leads to the ultimate question is that this will really be adopted when it's shown that it actually works. And I think there's a lot of anxiety over the use of these tools until that really is established, because as challenging and as the existing sort of methodologies are, and with all of their flaws, that you don't want to make it worse by using a technology that ultimately doesn't work. So I think lawyers need to know, and clients need to know that we're at a place where the technology can handle these challenges.
The proof is in the pudding, so we just got to get more people to eat the pudding. Certainly true. So Jeff, I'll give you the last word on the future.
And I think it's going to be an echo of everything that we just heard, but at the end of the day, I think it's going to mirror in many ways what we saw with the adoption of TAR in general, which was there were some very early adopters and proponents of the use, and the more general adoption took a while to take place, just because whether it be case law, comfort level, or a combination of both, it kind of forced the issue. And then plus the explosion of data made it even more necessary to be able to amplify the power of, whether it be a sole practitioner or small firms to be able to handle large data populations. I think the same thing is, we're going to see a very similar pattern as it applies to privilege tools, just because whether it be cost or concern or, a desire to be able to get affirmation from courts or other regulations to say these things are okay to use, until there's whoever said it earlier, attorneys tend to take things slow because it's practical for this industry to do so. And nobody's going to ask anybody to do anything differently, but when the time comes, eventually I think that the AI tools that are being developed currently and in the future are going to be welcomed with open arms, because it's going to make everybody's jobs easier, because they are going to be effective methods to be able to amplify everybody's skill set and make it more effective.
Let's hope so. So know we went a couple minutes past. Thanks to everybody for attending. Thanks to the panel for all of your great insights on the topic. Obviously, it's a very large topic to get into, and we could have easily spent probably another hour on it. I also want to thank CCPJ for sponsoring the webinar and for conducting the webinar, and H5 for sponsoring it. Thanks to all of you, and we will see you next time.